You're sitting at your kitchen table, and there's a letter in front of you from the other driver's insurance company. It offers you $14,000 to close out your car accident case here in New Mexico. The adjuster on the phone called it fair. She said it covers your medical bills and a little something for the pain. She made it sound almost generous, like they were doing a favor. Here's the part that nobody tells you. That number was not pulled out of thin air. Somebody built it on purpose, using a formula, and they built it to be accepted. Building that exact kind of number is the direct part of the defense job. So before you sign anything, stay with me, because by the end of this, I'm going to show you the one line item the adjuster is quietly counting on you to forget. And it is usually worth more than everything else on that letter combined. Let me walk you through how a car accident case actually gets valued in New Mexico, what pushes the number up, and what the person who wrote you that letter was hoping you would never ask about. Start with the frame. The personal injury case in New Mexico is built from two kinds of damages. Economic damages are the things you can put on a spreadsheet. Non-economic damages are the things that are real and painful, but never come with a receipt. The adjuster loves the spreadsheet part because it feels spinal. The other part is where your case is actually won or lost. The first line item is your past medical expenses. Everything billed: the ambulance, the emergency room, the imaging, any surgery, the physical therapy, the specialist visits, the prescriptions, every bill you can document from the day of the crash forward. Here is where most people who handle this loan quietly lose money. And this is the line item I promised you at the top. They think the case is worth the bills they're holding on to today, and it isn't. If your doctor says you need more treatment, or you need to come in for another round of surgery, an injection, a procedure, once the inflammation settles, those future costs belong on your case too. If a physician will support that treatment as reasonably necessary, its projected cost is part of what you're owed. So the person with a serious injury who settles today off today's bills is almost always settling for a fraction of the real number. That is not an accent. That is the whole strategy, and I have seen the defense do it time and time again. Next is lost wages, and this one has a hidden half most people miss. The wages you already lost, missing work, they're straightforward. But lost earning capacity, whether your injury quietly lowers what you can earn for years in the future, that's a different animal. For a minor fender bender, it barely moves. For a back injury, a neurological injury, anything that changes how you do your job, future earning capacity can be the single largest number in the entire case. So do not just sit there and add up the paychecks you missed last month. That's not the number. Ask what the injury costs you over the rest of your working life. Then there's pain and suffering. And this is the one that people get most uncertain about because there's no receipt to hold up, but it is real. It is legally recognized in New Mexico, and it can be a substantial part of what you recover. There is no formula in New Mexico law that spits out the number that you get for that. Adjusters lean on internal ranges and software as their starting point, but the real value tracks the severity of the injury. How well is it documented, whether it is permanent, how clean the liability is, and how much the insurer fears a jury. The better documented the injury, the higher number they will put down to stay out of courtroom. And here's something I can tell you from my time seeing how the defense behaves, and I want you to really hear it. When a claimant accepts early before they have finished treating, the defense counts that as a win. Not because the offer is fair, but because they closed the case before the full picture of the injury ever developed. And once the release was signed, they could never come back for the rest. That is the trap the friendly phone call is quietly walking you towards. There's also your property damage, and it trips people up constantly. Your vehicle, the diminished value if it was wrecked, the rental, while yours was in the shop. Those are separate economic damages. A lot of people take the property damage check and assume the whole case is now closed. And it is not, as long as the paperwork is limited strictly to property damage. So, settle the car, get your life back to normal, but do not sign or cash anything tied to a broad release until you know exactly what you are giving up. Read what is in front of you. Now let me be direct, because this is the part that matters most. Two people can walk out of the same kind of crash with the same injury and end up with wildly different settlements. The difference is almost never the injury, it's the evidence. What pushes that number higher? Clear liability, where it is not seriously in dispute that the other driver caused this. Serious injuries backed by consistent treatment. A clear record of how your life changed. A physician will tie the crash to your ongoing symptoms. And frankly, an attorney the insurer actually believes will take the case to trial. Insurance companies pay more when they think the other side is ready to walk into a courtroom. What drags it down? Gaps in your treatment, even a few weeks, because they will argue that the gap means you were fine. A prior injury to the same body part, which they will use to blame your pain on something older than the crash. Inconsistent statements, especially anything you said to the adjuster in those first raw days. And settling before your doctors even know the long-term picture. Have you ever had an adjuster tell you your claim was already fully evaluated early before you had barely started treating? Drop that in the comments. I want to hear how that call went. Now here's the New Mexico piece the adjuster hopes you do not understand. And I want to get the law exactly right, because this is where a lot of people get talked out of a case when they shouldn't have. New Mexico is a pure comparative fault state. That rule does not come from some statute that the adjuster can wave at you. It comes from a New Mexico Supreme Court decision, Scott v. Rizzo, way back in 1981. And what it means is this: Even if you were partly at fault, you still recover. Your award just gets reduced by your share. New Mexico does not have a cutoff that wipes you out for crossing some line, the way a lot of other states operate. Partial fault here shrinks that number. It does not erase it. And that matters because a favorite adjuster move is to hang some blame on you. You were going too fast. You should have seen them. You could have avoided it. And here's the thing. Even if they are a little bit right, in New Mexico, that does not mean you get nothing. It means the number gets adjusted. And those are not the same. They are counting on you not knowing the difference. So if the insurance company has already made you an offer and told you it is fair, hear this plainly. Their job is to close your claim for as little as possible. That is not a conspiracy. It is just what they're paid to do. And I know because I've seen it time and time again. And I've watched claims climb substantially once the full medical picture becomes available and is on the table, and the insurer finally understood that a case was ready to try. That is not a promise about your case. Every case is different. What I can tell you is that accepting an early offer before you understand the full value of what you're entitled to is the most common and most expensive mistake that I see. And once you sign that release, there is no undo button. So if you're staring at an offer right now or have not gotten one yet, you're just trying to understand the number, here's my honest advice. Do not try to figure this out alone. Not because a lawyer's magic, but because moving these factors takes someone who knows exactly how the other side is operating and how they built that low number in the first place. If you want to see what actually happens the moment you call an attorney after a crash, watch my video, Why You Need an Attorney After a Car Accident. Do that next. Then, when you're ready to talk about your specific situation, call us at Hudson Injury Law, 505-416-4150. The consultation is free and there is no obligation. And if it turns out your case is not worth pursuing, I'll tell you that straight ahead. What did the insurance company tell you your case is actually worth? Drop it in the comments below.